Rosita.
Hello everyone, it is an honor, even before being a pleasure, to be here today in another role as a researcher. And I will briefly discuss about a paper that I wrote on a scientific journal, Iura and the Legal System, on the reform on the Italian honorary magistracy. The title of my report is Yet Another Incomplete Reform of the Honorary Judiciary, towards the end.
More distance.
Okay, more distance. Towards the end of the figure of non-professional judge, or towards a new beginning. The troubled path of reforms of the honorary judiciary seems to have come to an end, with the latest reform contained in the last financial maneuver and related to the changes to the discipline of honorary magistracy as regards the legal, economic and social security regime. The new provisions are aimed at giving a definitive response to the European Commission's findings regarding the infringement procedure of 15 July 2021, followed by a supplementary letter of a formal notice in July 2022 and a reasoned opinion in July 2023. The regular infringement procedure is made by 3 steps, as you know, to align with the European legislation on fixed term or part-time work and working hours. The objections were raised by the European Commission not only with reference to the condition of honorary magistrates in service on 2017, but also for those who assumed the functions, since Italy did not provide substantial answers or adopt measures to remedy the issues identified and to prevent any further abuse. The first remark of the European Commission were made to Legislative Decree 2017, known as the Orlando Reform, from the name of the Minister of Justice at the time. The first to be censored by the Court of Justice of the European Union with the UX ruling for having violated the European regulation on fixed term or part-time work. Over the year, stubbornly partial and incomplete reforms censored by the European Commission and which have made the European judges' intervention necessary at the end to ensure compliance and effectiveness of European Union law, have highlighted the lack of cooperation between the European Commission, the Italian government, and the Italian magistracy. The interpretation and application of Court of Justice's decision are of a contrasting sign, especially on the concept of comparability of the honorary magistrate to the professional ones, and on the condition of fixed-term honorary judges. Such interpretation almost constantly to the detriment of honorary magistrates, with rare exceptions, with sometimes questionable reasons, have in fact nullified the right to the effectiveness of judicial protection before an impartial judge, an important and significant principle of the European Union law, which you could find in the Article 19 of the Treaty of the European Union, due to the resulting distrust in any form of compensatory protection. Furthermore, a number of dissonant regulatory provisions intervened during the proceedings, some of which resulted in a no result, just causing the prolongation of judges' full-time functions and the objective impossibility to find shareable and fair legislative solution for all the categories of the honorary magistrates, which are honorary court judges, honorary deputy prosecutor, and justice of the peace, especially in line with the constitutional and European principle. The resulting picture is the inadequacy of the regulatory provision censored by the European Commission, culminated in the Cartabia reform. which provided for an anomalous stabilization system both in working and pension terms. The stabilization, which in fact conceals a stability in functions and the increase of the age limit from 68 to 70, in any case, does not entail a transformation of the relationship into permanent employment, and therefore it is not comparable to the so-called tenure, which rather requires a real competitive procedure for the definitive permanent employment for skilled workers, even if precarious. Honorary judges have repeatedly been defined as voluntary private workers who perform public functions. However, the verification of professionalism and or suitability is not considered to be such. The reform of 2024 confirms that the stabilization in the function is considered a compensatory function in specific form, which involves the definitive waiver of any further claim as to the previous honorary magistrates and honorary relationship. Although confirmation up to 70 years does not imply a change of status, but only determines the extension of the honorary relationship until retirement age. The issue relating to honorary magistrates who have ceased the function also remain unresolved. The reform recognizes to honorary magistrates a lump sum compensation, which would seem to take on a merely symbolic value, as highlighted by the European Commission. Furthermore, it is not dissuasive to unlawful conduct to the wide and frequent recourse to non-professional judges by the Italian government. Such indemnity cannot be considered an effective sanctioning measure to ensure a necessary deterrent effect against abusive practice of recourse to fixed term and or part-time employment contracts. It should be added that many documents relating to the activity carried out are no longer available, with concrete risk that the compensation will not be made possible or will undergo an appropriate reduction for reasons not attributable to them. With regard to a possible increase in the one-off allowance that is subject to taxation, an amending proposal submitted to the Commission was withdrawn and no longer represented. Well, what are the concluding remarks? Despite the efforts made with the new discipline, we are still far from a definitive resolution for a hybrid function not provided for by the Italian Constitution. The honorary judges saga remain suspended. In fact, honorary magistrates who have been confirmed have not acquired the specific status of professional judges. Furthermore, the predominantly compensatory nature of the measure envisaged does not guarantee most of the honorary magistrates confirmed, who, in any case, have ceased their function, who have once again reported to the European Commission the discriminatory conduct of the Italian government. However, taking into account that in the Italian system the use of the proximity judiciary has become disruptive and a constant necessity with the expectation of a conspicuous increase in skills for the years 2025. Will honorary magistrates such as the young Holden be able to find a place to feel at home? I leave you with this question.